Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case Yates versus United States. This case was heard in the Supreme Court of the United States in the year 2015. Let's go ahead and jump into the facts of the case. So a fisherman was fishing for red grouper. He was fishing for a bunch of red grouper and he had caught a bunch of them. They were on his boat. And then a federal agent came and saw that he had all these groupers and noticed that they were undersized. They weren't large enough to keep. He was supposed to release these undersized red groupers so that people could catch them in the future. Well, the federal agent says, leave the fish on the boat and then we'll kind of deal with this when you get back to port, okay? So the federal agent, leaves him and he keeps sailing. Well, the captain of the ship says, hey, let's just toss these all back into the ocean. So they toss the dead, undersized red groupers back into the ocean. Now, this fisherman is prosecuted and he's charged under United States law with violating U.S.C. 1519. Okay. Now, what this provides is that if you knowingly alter, destroy, mutilate, conceal, cover up, falsify, or make a false entry in any record, document, or tangible object with the intent to impede, obstruct, or influence the investigation of the proper administration of any matter within the jurisdiction, basically you're guilty of obstruction of justice. So this statute basically says you can't destroy evidence. And if you destroy evidence, you're going to be guilty of the obstruction of justice, the violation of this code, and you could be imprisoned up to 20 years. So this fisherman is being prosecuted for violating this statute. Well, it's interesting to know where this statute came from. Well, it came from the Sarbanes-Oxley Act. This was passed in 2002. And Congress's purpose when it was passing this act was to combat accounting fraud. So when we think about the statute again through that lens, we read, whoever knowingly alters, destroys, falsifies, or makes a false entry in any record, document, or tangible object. So the fisherman here is arguing that, this statute might apply to an accountant, to a banker who destroys banking evidence or accounting records, but it certainly doesn't apply to me. I was just destroying a fish. I threw a fish overboard. And this statute is not meant to apply to me. Congress didn't intend for this statute to cover, tossing fish back in the ocean. It meant for this statute to cover people who were falsifying accounting records and then destroying them. So the argument here from the fisherman is just centered on Congress's purpose was not for me to be liable for breaking this law. It was for accountants. Okay, and the court finds this persuasive, and the majority is written by Justice Ginsburg, and kind of strange bedfellows in these opinions. Justice Ginsburg joined by the Chief Justice Roberts, Breyer, and Sotomayor, and then Justice Alito also concurs in the opinion. Their argument basically centers on the fact that this was passed in the Sarbanes-Oxley Act. They accept the petitioner's argument. This wasn't meant to apply to fish. It was meant to apply to accounting. So they look at the congressional intent as in what was the act that Congress was passing when they put this into the United States Code to basically figure out what Congress's intent was. Further, they argue using the canon Nocere Associus, which basically is saying that a word is illuminated by its neighbors. A word is illuminated by its neighbors. A contextual reading allows us to understand the meaning of a word more clearly. So what they say is, you can't really falsify or make a false entry in a grouper. And since those words are in that sentence, falsify, false entry, we should look at the word tangible object in light of those other words. We shouldn't just look at it isolated, because they acknowledge that if we just look at any tangible object, that language in an isolated, strict construction sense, well then obviously a grouper is a tangible object, so it probably should be covered by the statute. But they say, we shouldn't read a statute. We shouldn't construe a statute that strictly. We should construe it reasonably. Now the dissent doesn't find that argument to be persuasive. The dissent is written by Justice Kagan, Justice Scalia, Justice Kennedy, and Justice Thomas all joined in the opinion. What Justice Kagan says is, this is plain. We don't need to try and figure out some ambiguity here. We don't need to create ambiguity when there is none. It's pretty obvious that Congress used this broad language, any tangible object, to include scenarios like the one before us. It was using this broad language because it was casting a wide net. If you'll forgive me, it was casting a wide net to try and capture all types of destruction of evidence. And it wasn't just talking about accounting. She rejects the argument that we should consider the title of the act or what bill this provision was passed in as persuasive as to Congress's intent. It's pretty clear, and there's legislative history to support my position, that Congress was meaning to cover the destruction of any evidence, not just documents used in accounting. And she doesn't find that argument that very persuasive that the majority relies quite heavily on. So this case is interesting because you see the divergent views. It splits across political ideologies. So there's a few questions to consider. The first would be, should we look at the act's name? Should that matter? Should the bill's name matter? The Affordable Care Act, the Equality Act, the American Rescue Act. Should those things matter? Or should we just look at the words of the statute? And Kagan would say, no, they should just kind of be given minimal concern, whereas Justice Ginsburg, in her opinion, says, yeah, we should look at it. It's persuasive evidence of Congress's intent. And it's a very good debate, something to think about. It's less persuasive that the title is an actual representation of Congress's intent when Congress is passing omnibus bills, which has happened in the past, where they're just throwing all sorts of provisions into a single bill. How then are we supposed to recognize that the name of that has any persuasive meaning as to the interpretation at all? And second, should the purpose of the act matter? Forget about the name. Should the purpose of the act matter? Well, the purpose of this act was, it's illuminated by the evil that this act was trying to remedy, which was the Enron accounting fraud. Now, should that matter, or should we just take the words at their face value? You think about the reasonable citizen. Does the reasonable citizen think about how the act was enacted, what Congress passed this, what evil were they trying to remedy? Or does the regular citizen just look at the words in the code and just, read them at face value and not really care about what act they came in? I think it's a reasonable argument to make. Artful pleading and good lawyers certainly rely on the title of the act, the purpose of the act, but does a reasonable citizen really even know? Or do they just read the United States Code? And third and finally, something to think about, which the justices also discuss, is the rule of lenity. The rule of lenity basically says that when a statute is ambiguous, we should construe it strictly in favor of the criminal defendant. So if it's ambiguous and there's one interpretation that could lead the criminal defendant to 20 years in jail and another that could lead the criminal defendant, scot-free, which way should we construe it? The rule of lenity says we should construe it in favor of the criminal, saying that, this person shouldn't go to prison because the statute's ambiguous. They weren't really put on notice about the illegal act that they were doing. And the rule of lenity here is invoked. It's something to think about. How far should we take the rule of lenity? Should we allow it to apply in any scenario where someone could argue that a word's ambiguous? Because there's plenty of scenarios where words that are seemingly plain have been argued to be ambiguous. Or should we just, more tightly use the rule of lenity to scenarios where, it really is ambiguous? And I think in this case, the split on the opinions, the 5-4 opinion shows that this was an ambiguous provision. So invoking the rule of lenity in favor of the fishermen is probably a just outcome. So thanks so much for watching. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button. And I hope you have a nice rest of your day. Bye-bye.